Oh, there we go. Hello, everyone. My name is Marcio Katz. I'm the CEO for Get Global International. We are a multinational data privacy consulting firm with operations in the US, Europe, and Brazil. And this is our podcast, our Get Privacy podcast. And today, I would say that we have the great pleasure to have Odia here with us. First of all, how are you today,
Good.
Odia?
Nice to be here.
Okay, and that's fantastic. I think we've been blessed with all the guests that we are being able to bring to our podcast, and today is one of those days. I've been following you on LinkedIn. Yeah, I really enjoy the content that you have been posting lately, and today we are going to talk, about the bipartisan U.S. data privacy bill, and we've been waiting for this moment. But before we start talking about the bill itself, let's talk about yourself. How do you get involved with data privacy?
So I started out my career in doing tech transactions. And so I was always involved with companies that had a lot of data involved in their, operations. And then I became more interested in it, and I did an LLM in European telecommunications data, which had a big European data privacy component. And so I've been doing privacy ever since, with the European emphasis. And in the beginning, when I was practicing and I said, oh, I'm a privacy attorney, and being from in the US, being in the Philadelphia area, I was asked, oh, so you do data breach? No, I don't do data breach. I do, privacy compliance. And now with the obviously CCPA and the new state laws, and now the federal privacy bill, this is more common practice and applicable to a lot more companies. Whereas in the past, it was, okay, you were a regulated entity, you were Graham-Leach-Bliley, you were, HIPAA. But now, obviously, in the past few years, this has become a much bigger topic in the US. And I foresee that it's exponentially going to continue that way.
Yeah, we've seen the same movement in other parts of the world. We've seen that in Europe. It's something that started to get bigger and bigger, and then in Brazil and some other countries all around the world. And I think that the U.S. is right on this stage that you have just described. Things are just getting bigger when it comes to data privacy. We had a great episode with Kirk, and he explained it all in details, every single step of this U.S. journey on data privacy. And I think that most of data privacy professionals are excited about this moment. And as you said, you foresee this getting bigger and bigger. So what do you think is going to happen in the near future? What's your feeling about that?
Specifically with respect to the bill, or generally in the space?
Generally in the space.
I think that, we are at a point where, I think that the trend here is going to be up, in whatever form this takes, because I taught privacy law at a university here, and a few years ago. And I remember at that point asking the students, okay, well, what is privacy? And since originally I'm from Israel, and my perception of privacy in in Israel is different, and there's a privacy law, national privacy law, et cetera. So there's actually, by the way, a very big background on privacy in Jewish law as well. So I was interested in hearing, and all of these, guys and girls who are 23, 24, 25, a lot of them said, privacy is for the government not to interfere in my life. And I'm like, guys, are you not on, social media? What's going on? So this has changed dramatically. I mean, this was 7 years ago, say 8 years ago. The perception is very different. If you now ask people, young people, older people, about privacy in the US, everybody is aware that there's a huge component with respect to private companies, with respect to now, of course, there with the Dobbs decision, there's a huge emphasis on health information, sensitive information, because of the pandemic. Obviously, there's a huge emphasis on, the use of information by private companies. And so once in the US, there is a very big influence on companies and on the market and on regulation by the market, by companies. And the opinion, I think the public opinion is already at, okay, this is important and we need something to regulate it. And we need something to regulate it, to a large extent. And then at that point is like, the poem, right? Like the road bifurcates, and now we're going to see which road we're going to take, right? So there's one road that says, okay, well, we can't get our act together to get a federal privacy law. So the states are, and I've read interviews by, states attorneys general, and they were like, well, there's a vacuum by the federal government. We're going to fill it. And so we have 5 states that have already filled it. And if the gap continues, there will be more states that fill it. With all that entails, right? It's a patchwork. It's been called Patchwork 2022. We know this from the data breach area where we have 50 plus laws, right? State and federal, with different provisions on data breach. And it's, difficult for companies, and it's, fun for, data breach attorneys. But either that continues, or we actually can get, now, we're further along than we've been before. It is a bipartisan bill, and that may go forward. I used to say that, because the issue with the privacy law in the US, the federal bill, we used to joke that, it's like in the TV shows, right? That they say, no, people or animals were harmed in the making of this movie. It's like no fair information privacy principles were harmed in the bipartisan debate with respect to privacy law. The debate was never about the privacy. The debate was about preemption. It was about a private right of action, and it was about enforcement. And if the parties are in the draft, there is a compromise. If the compromise sticks on those issues, I think that the privacy issues are going to be easier to reach an agreement about.
Mm-hmm. Perfect. I love it. Now, diving a little bit into the bill itself. I'm going to follow here one great article that you have posted on LinkedIn on the bill, on the federal bill. And the first thing that you mentioned is that I feel that you felt like it should be the first thing to be addressed is who is in scope. I mean, in this specific federal bill. Can you explain to us, how this federal bill address the entities that are going to be in the scope of this data privacy bill?
Yeah, so the first thing is it is a broad definition of entities. So whereas right now, the issue with the US privacy laws, or at least the issue that we used to have with the US privacy laws, is that they were sectoral laws, right? So we had HIPAA, and we have HIPAA, we have Gramm-Leach-Bliley, we have COPA for for health, certain specific subset of health information, for certain financial information, for children's information,
Children.
for GINA, which is the genetic law, which has been getting kind of a stronger, like getting kind of second wind now because of certain questions related to COVID and stuff. So like we had these sectoral laws, right? And now, like CCPA started being comprehensive, but CCPA has thresholds and basically is meant to apply to larger companies, right? And so in this situation, this takes an approach which is closer to the approach, not exactly, but closer to the approach taken under GDPR, which is that, first of all, the first thing is this ties it to the authority of the FTC, because that was one of the things that was going to be discussed, was as I said, one of the points of contention between the Republicans and the Democrats was, okay, who enforces the law? And the law, and we're jumping a little bit ahead, but the law gets to be enforced by the FTC, the Federal Trade Commission, which has been, the de facto privacy regulator in the U.S. So given that, right, then the first thing is that the law is going to be, the companies subject to it are going to be the companies that are subject to FTC jurisdiction, which is a lot of companies, but not all of companies, plus common carriers, plus nonprofits, which this is a very different kind of deviation from what we see in the California law, in the other state laws, which carved out nonprofits from the scope. And then the other piece, which is similar to California, which is entity that is controlled or controlling or shares common branding. This is like pure CCPA language, with an entity that is covered to that is covered by the law. So it's like you or your subsidiary or your parent company or whatever that is covered by the law. And then you have, in order to, I don't know, like the insides of the discussions that were during the discussions, but then you have another higher threshold with more obligations on what they're calling large data holders. So instead of saying, okay, we're not going to apply the law to big to smaller companies at all, right? We're saying, okay, yes, it does apply, but then we're going to have a higher, like more strict requirements for large data holders that have really high gross annual revenues of $250 million or more, data of 5 million individuals, sensitive data of 100,000 individuals.
I see. On this matter, I usually say that the bill is becoming a little bit more sort of GDPR-like regulation on this matter, but with an American flavor, because there are things that you won't find on this matter on the GDPR. But it seems that the bill is a little bit broader than the others legislations that we've seen in the U.S. so far. The second topic that you mentioned on the article that I have mentioned it before is service provider, the definition of service provider. Can you explain to us how this topic is addressed in this bill?
So this is, so here, interestingly, the terminology, by the way, of this law is like, unlike, so the US state laws, right? Sometimes some of them track GDPR on terminology in order to make it easy, right? Controller, processor. CCPA does not. This law does not. Confusingly, by the way, and this is one of my pet peeves about this bill, is that the name for the key for the key entity, what we call a controller in GDPR and a business in CCPA, is called a covered entity, just like under HIPAA. But why? Like, why make it difficult for us? The service provider is a CCPA term, right? And generally speaking, it tracks the definition of CCPA, but it carves out entities that process information outside of the direct relationship with the entity. So it's not, this is where it's going to get a little bit confusing, not confusing, but this is where it's going to get a little bit complicated, because there are, by and large, even now, if you, for CCPA, for example, if you are under GDPR, if you are a data processor, you will be a service provider under CCPA. If you are a service provider under CCPA, you may not be a data processor under GDPR. In some circumstances, you may be a controller. So in this situation, it changes it a little bit, but there's going to be probably like edge cases where there are going to be issues. But I will say, in the defense of the US approach, one super common situation that we find for data processors under GDPR is that your core business, everything that you do, is actually in the service of the controller, but you use the information to improve your machine learning or you use the information to improve your product internally, right? That immediately makes you fall out of the data processor designation, even if you don't, actually use the identified information in a specific way. So the U.S. approach is kind of more, business friendly in that regard.
Mm-hmm. And I feel that that's pretty much what they are trying to do. I mean, they are trying to find the balance between privacy and innovation. And I quite like that because I feel that the GDPR sometimes is too much privacy and not so much innovation. And then there is a very interesting topic here, which is the definition of personal information or personal data or whatever. I mean, it brings the scope of what exactly are we talking about, and how does the U.S. bill address this topic in a specific?
So generally, right, it tracks CCPA, and it looks at this formulation of can be linked or reasonably linkable directly or indirectly with an individual. It's pretty broad, right? It calls out derived data, unique identifiers. Unique identifiers are specifically, because of this discussion, specifically in the ad tech industry and all of the issues that we had in the CCPA regs, they actually list out beacons, pixel tags, mobile ad identifiers, customer number, unique pseudonym, other alias, telephone numbers, persistent or probabilistic identifiers. I had a conversation with a client yesterday who insisted for the first half hour of the conversation or not half hour, but first beginning of the conversation, we don't have personal data. We don't have personal data. And I said, okay, well, tell us the fields. And they went through the fields. I'm like, this is per se personal data now, right? But they're like, well, we can't get to the individuals. Well, you can single them out, and therefore they are, it's personal data under GDPR and it's personal information under CCPA. So I think that the definition is pretty broad, and then there's a couple of, the other thing that they do that's very similar to CCPA, and I think this thing is here to stay already because all of the other state laws are doing it, is this de-identified data concept. It is going to be, smart people probably have or need to look at the Venn diagram between anonymous information, pseudonymous information under GDPR, and de-identified data under the U.S. laws, because they are not one-to-one comparison, and that creates a complication for companies. But the de-identified data, the structure that's interesting is under GDPR, anonymous data is data that you just can't get back to the person ever the end. Okay, it's like the result. The test is the result. How you get there, more difficult. There is an EDPB guidance, there is ANISA guidance, there is, other things, but, it's kind of your problem. In the US, there is an approach that says, okay, the data needs to be de-identified, but also you need to kind of show your work on making sure it's de-identified and stays that way. So you need to have reasonable measures to prevent re-identification. You need to publicly commit not to re-identify. You need to actually not attempt to re-identify, and you need to contractually obligate your downstream not to re-identify. And these are requirements that you don't have on their face under GDPR. Maybe they're implied, but this sort of is something that tracks CCPA. And then there is this definition of biometrics, which is broad and doesn't specifically require you that you use it for identification, similar to BIPA, which is a broader definition of biometrics than the one that we're used to, but similar to GDPR, where you have biometrics and then you have Article 9 when you're using it to identify the person. You have a concept of, similar to both CPRA and GDPR, you have this concept of sensitive covered data, right? And so it kind of tracks CPRA, but it's got a few, we'll call them surprises, right? It includes biometric, genetic, health information, precise geolocation, private communications, cross-site tracking, even though I think that so obviously this is a bill and it's undergoing iterations. It's already gone through 2 iterations.
Sure.
That some of them I'm going to track, but we're sort of following them. I think the cross-site tracking got dropped from the definition of sensitive information in the draft that was filed like 2 weeks ago with Congress. Calendar information, I think that was also dropped. It was interesting that it was added in the first place. Information identifying the extent or content of viewing television, cable, or streaming media. And then the other thing which is interesting and stuck in this draft is under 17, information of under 17s. This whole concept of people under 17, where until now we had COPA, which is under 13, we had CCPA, which is under 13 and under 16, then above 13, under 16. We had GDPR, which is also has a range that ends at 16, and this is 17. So this is going to be really interesting. Some kind of U.S. specific pieces here is this. One, precise geolocation, specifically called out as sensitive information. Precise geolocation is a big deal. People, regardless of what's going on here, I think it's going to stick as sensitive information. It's sensitive information in all of the other state laws. The FTC issued a position. I don't know if it's like a blog post 2 days ago. I also posted it on LinkedIn. Everybody who's interested,
I saw that.
Free to follow and see. But the FTC, especially, this has been a big deal anyway, and we've seen it in the Tim Hortons decision in Canada, which focuses on precise geolocation. We see it obviously with connected vehicles, but now, especially in following the Dobbs decision, precise geolocation is very important. Precise geolocation can, relate and connect you with abortion clinics and things like that. Google has said they're going to, delete that information. And the FTC issued a paper that said, hey, health information, location information, we are going to strictly enforce this. We already have, and we're going to continue to do that. So precise geolocation is important. The sticking point, by the way, is precise geolocation has like 4 different definitions in the different laws. And this definition is even different than the other. It says sufficient precision to reveal street level location within 1,000 feet range. That definition is different than everything else. Everything else is like 1,650 feet, 1,750 feet, 1,850 feet. And of course, in Canada and other places, it's 500 square meters. So hopefully we can get something we can decide on, but precise geolocation is definitely a big deal. So you need to kind of worry about it. And then the other piece is, the final piece is publicly available information. In that situation, this is a US approach, which is different than the European approach. European approach, public data is data, is personal data. You're in public, okay, yeah, sure, but it's still personal information. In the US, the approach here, I think you do need to kind of factor in all of the years of like the Katz decision and all of the decisions in the US with respect to reasonable expectation of privacy and, all the, Fourth Amendment and stuff like that. And see that this is like, but what is in public? What do you mean it's in public? Mm-hmm. And so there is a carve out for certain things that are publicly available, not everything. And the new amendment actually carved out inferences made from publicly available information, but the carve outs does not apply if it's biometric, if it's sensitive information, if it's the genetic information, if it's publicly available information which has been combined with personal information. So it's broader than the GDPR approach, but it's not a free for all, especially for sensitive information, because that is, again, going back to our issues with Dobbs and with location and sensitive information. If you start, and the FTC in the paper and also this bill calls out data brokers and data aggregators, because some of this information, which is publicly available, could still do a lot of damage to the right of privacy.
Yeah. So far, I feel that we will definitely not follow the same European standard. It's going to be a different standard on how the US is going to regulate data privacy. Because the GDPR, it follows one standard. It means basically that there are 6 different situations that you need to fit into at least one of them, which are the legal basis. Once you classify for one of them, then you are going to be able to process personal data, and they are going to give some principles, some boundaries where on how you can process the personal data. And then there are the data subject rights that you also need to comply with. That's pretty much the European standard. The US standard so far, it seems something a little bit different. And I feel that the GDPR it has broader definitions of things. And this bill is getting a little bit deeper in some specific topics. For example, under the GDPR, the definition of personal data is any information of an identified or identifiable person. So that's a broad definition. Under this bill, they try to describe what is a personal information, and I feel that that might have some good things about these standards, but also I feel that there will be some gaps that we'll have to wait how the whole legal system is going to fill those gaps. What's your opinion about that? About the difference of these 2 different standards that we are seeing between the GDPR and this US bill?
So 2 things. Let's talk about them separately. First of all, the definition of personal information, personal data, covered information, whatever we call it. And the second one is the legal basis situation.
Mm-hmm.
And I think,
Mm-hmm.
so first of all, I think the definition of personal information under CCPA, CPRA, and we'll see where it lands in bill. I don't think that it's necessarily narrower than GDPR. It arguably is broader than GDPR. What they did was this formulation, it doesn't use identified or identifiable, but it says reasonably linked or linkable, which is basically the same, because identifiable, the definition of identifiable is when you can identify it by linking it to other pieces that are reasonably available. So that part's similar. I think I don't know, but my personal opinion of why, so it starts with this definition. It says, blah, blah, reasonably linked or linkable, including the following. And so it's a non-exhaustive list that is actually listed. I think the reason it's actually listed is that, and this happens all the time when in conversations that I have with clients or when I do webinars, in Europe, the concept of personal data, what is personal data, is so ingrained because of not even just GDPR, but the 1995 directive, and in some countries even before that, the concept of what is personal data is known. I mean, there are still, by the way, when you get an access request and you still need to parse through all your emails and things, you really want to kind of dance on the head of the pin on what is personal data and produce or not produce. But people know. In the US, I can't tell you how many times people have told me this is not PII. And I had to say, number one, PII is a term that only applies to the requirement, obligation to notify with respect to a data breach under data breach laws. And it is much narrower than the definition of personal information under CCPA. This concept, I mean, people would meet, what do you mean email address? I'm like, it applies to email address and phone number. What do you mean email address and phone number? What do you mean, like shipping address? What do you mean, like purchase history? Like, what do you mean cookie? I can't tell you how many privacy notices say we connect personal information and non-personal information. And then there's a list with non-personal information, including IP address and MAC address. Like this concept that personal information is only like government ID, driver's license, medical information, health insurance, like those critical things is so ingrained in, the US kind of, perception because of how the laws were, that I think this is actually, helpful to get, the fact that you're listing, unique identifier, probabilistic identifier, beacon, pixel tag is sort of preempting the question of, well, this is not personal information. So that's on that. I think at the end of the day, CPRA, I think, is arguably broader than the GDPR personal data because it links it also to devices. But the bill, I think, is sort of around the same. The other issue, which is legal bases or not, that is actually an interesting concept. The legal basis thing is a GDPR concept, which has since been adopted in all of the GDPR-like laws, right? But it is absent from a lot of the other laws, right? Like that Canada doesn't have these legal bases. Israel doesn't have legal bases. Even, countries that have adequacy don't have legal bases. That's number. So this is a very European concept. I am, again, curious if somebody would like to map it. I mean, this happens, I talk a lot with, I have my privacy friends, and we talk about like nerdy privacy questions and compare notes. But, to see like, okay, how would this situation be handled differently if it's under GDPR or under the US laws or under Canada, right? And first of all, I want to say that by and large, right, you do reach a similar result in the majority of the cases, in my opinion. There are going to be edge cases where you're not, and then it's kind of not always the case that the GDPR approach is the better one. It seems, not even just my opinion, but European practitioners too.
Mine.
So yes, we don't have legal bases, but we do have something that is closer to GDPR than what we had. So first of all, we have data minimization. And we have this concept of sort of, which is very equivalent to Article 5 fair and lawful. And this is also in CPRA. So, and different from CCPA, where we didn't have it at all. And all you had was, okay, I collect, therefore I am. And I will document it and I will maybe give you choices. But the fact that I'm doing it, I have the right to do it. And that's no longer the case. You no longer have a by definition right to collect anything you want, however much you want. Now you need to do things which are reasonably expected by the individual, which are necessary and proportionate to what you need to do, to a service requested, to a communication, to a purpose expressly permitted. So first of all, fair and lawful captures a lot of stuff, number one. Number two, and this is different in the bill than in CPRA, even though the CPRA regs are sort of an upgrade again from CCPA, you need consent for a bunch of things under the ADPPA, where you didn't need consent under the CPRA, CCPA, other state laws. So in that situation, like Canada, for example, right, you also have fair and lawful data minimization. You also have consent, and you don't have, built in, you have, some bits of legitimate interest and obviously compliance with the law and obviously necessary for the performance of a contract, but not the entire kind of GDPR legal basis structure. And I think, I'm not sure, I think that the UK reform maybe was also looking at these like legal basis thing because it's complicated. So I think
it was one of the first things that they have done with the Brexit when it comes to data privacy. They reformulated the legal basis. Even in Brazil has 10 different legal bases. That means 4 more than the Europeans. So, but anyway, go ahead.
Is it working better for you?
No, I don't like this legal basis standard. I feel like the way that things are done, for example, in Canada and even in Israel that you mentioned, for me, it makes more sense. But as a European lawyer, and I've worked with the Brazilian government to draft the LGPD, and they have decided to follow the GDPR standard. We just tried to make things clear, because there are some things that you might get in some debate if that fits or under certain legal base. So we decided to make things clear and give more options, like put this way, uh, especially from my perspective, to the business to fit under certain legal basis. But I don't like the standard itself. But once they have decided to follow this standard, I just try to help, to make it easier or clear to the society itself. I mean, to the individuals and also to the business. But I don't like the standard itself.
And I think, that it's interesting again to like look at specific situations and see how they end up. But when you really seriously apply one, the data minimization standard, do I really need this? Do people expect this? Are people given enough information to make a decision? Are they able to make a right decision? Or is this a bargaining power situation where they feel pressure? Like if you put all of that into it, I don't think that there ends up being a huge difference between, the end result under, these types of laws and GDPR. One difference that is, I see creating a lot of issues is the e-privacy directive, where regardless of what's fair and right, you need consent for, the collection of something or accessing it from a device. And where e-privacy is factored in, I do see differences between the European approach and the other approaches, because you just can't do it. You just can't do it because you've got to have actual consent.
Yeah, for sure. And talking about the consent, which is one of the legal bases under the GDPR, I just want to make a comment, because I've seen people making one comment that for me feels wrong, when they say that the CCPA is opt-in or opt-out and the GDPR is opt-in. For me, it
Neither
doesn't
of
make
them is
sense.
correct. Neither of those
Yeah,
statements is correct, right?
yeah.
CCPA, first of all, is not opt out in all situations. There is an opt out in certain situations. For example, in connection with a sale under CPRA, for example, in connection with using sensitive information for more than the necessary purposes. There is an opt in certain situations, for example, an opt in after an opt out, or an opt in by a child, right? But generally speaking, first of all, it's not like an opt out law. You don't need an opt out for everything. And the other thing, I mean, this I've seen continuously. It's like one of those like GDPR myths. GDPR is not a consent law, right? Exactly. We
No,
just
it's
said.
not up-to-in, because you have like as 5 different other legal
Yeah,
bases
exactly.
that are. So it just doesn't make sense for me. I think sometimes people try to simplify things, and they just miss the point.
My favorite
And
one, which I've seen on a lot of tweets, which is these cookie consents under GDPR are annoying. Well, no, they're not under GDPR at all. So, and arguably some of those that are annoying might not even be compliant with the e-privacy requirements. But anyway.
yeah, well, the consent, I mean, is a great topic. I mean, we would be able to talk, minutes and minutes about the consent. But I want to jump into the privacy by design, because I'm passionate about it. So I wanna hear from you. Uh, how does the U.S. bill address privacy by design?
So first of all, it's addressed is the cool thing, right? So
Yeah.
this is specifically called out. And it has an express duty to implement policies, practices, and procedures with respect to covered data to mitigate privacy risks in under 17s for the use of your products and services. And it says including design, development, implementation, training, safeguards. So this is basically, so first of all, it iterates the concept. It codifies the fact that privacy by design is a thing, under the US federal law, which basically is a lot because now it is a not only a same as with GDPR, right? GDPR has privacy by design as a specific obligation, where and not just as a way to demonstrate compliance with the rest of the obligations. So I think that's important, that it's actually stated out loud, and it's actually, the law itself basically says the principle, which is we expect you to think about this and to incorporate it in every stage of the product design, implementation, development. And that is, there are a lot of different, since this concept was, coined by Ann Cavoukian, there have been a lot of iterations of it, but the principle is you've got to take privacy and the most privacy friendly aspect in every stage of the design, and that's actually stated there. The other thing that they're basically saying is that, okay, this is just the principle, and the FTC is going to issue privacy by design guidance, which will give you a better idea of how to actually make this happen in real life, because it's really complicated. And I see this in Europe a lot. The EDPB guidance on data protection by design and by default is, difficult to implement. It's got a lot of concepts and not a lot of specifics. The AEPD guidance on data protection by design by default is good. It's much more specific. It actually goes into some specifics on, okay, here's where you get, if you have a dashboard, here is where you do give people the choice. Here is where you don't give people the choice. But it's a very difficult, very new concept. And, and this is going to be a thinking change, right? A shift in how you look at it, because it's not only, it's not primarily the lawyers that need to tack this on the back end. It's going to be the companies that need to think about it, and to think about the design, and obviously incorporating into this, which, even though it's been addressed specifically elsewhere, deceptive design, which is the new name for dark patterns, right? So all of that is now something that's expected of companies in the U.S. as well.
And how do you think this is going? It's going to work in the companies when there is a project that we need to think about the privacy right from the beginning, because this is pretty much the DPO role. I mean, the data protection officer under the GDPR. So our clients are advised to involve the data privacy officer right from the beginning of the project, beginning from scratch. How do you think how is it going to happen in the U.S.? Because there is no such data protection officer role under this bill. But you do have your experience, and you have your clients, and you've seen this before. How do you feel that the companies are going to deal with this?
So I think, and this is a question I think it's two things. How are companies going to deal with it? One, it's difficult, right? Because the first thing is realizing it's the same as, the first thing we did was what do you mean email? What do you mean phone number? And it's what do you mean I need to involve people from the beginning of this? What do you mean? I just need legal to sign off on my thing. I literally had this happen with a client 2 days ago, where it's oh, we're doing this. Here's the write-up. Here's the text. Can you look at the text? I'm what do you mean look at the text? What about this and this and this and the other thing? And we had to kind of change it all, and last minute fire drill, change the structure because it had issues, right? So one, it is a big shift change, right? It is a shift change. It involves, all of the stakeholders that need to think about it, and and the questions that we've had, for clients for a long time. It's oh, can we put the slider here, or place it here so people don't know? No, you can't do that anymore. They just can't do it anymore. Number one, specifically the DPO piece, I think, is the least of the issues, right? Because this is a big shift change. I think companies can do, whatever. And I think that there is a requirement in the law, if I recall correctly, to actually have a privacy officer and a security officer. So they're not the EU DPO, but there is a governance type structure. And this is something that I've always talked to clients before. When I had clients that are not subject to GDPR, and said, well, do we need to have a DPO? And the answer was, one, DPO is a very specific term, which even
Mhm.
per the opinions of the European supervisory authorities, if you choose to say that you're a DPO, then you're subject to the GDPR requirements. So like, why? If you don't have to. But
So you can't
realistically,
be a global GPO. I mean,
if you
I mean,
call them, I think there's an ICO said it and a couple of others. They said, well, if you don't have to have a DPO, but you choose to be a DPO, then you're subject to all the DPO things. So, but you can be like a CPO or a potato O, I don't know, whatever you want to call it, right? And if you substitute, you need to, and this is not new, right? Like this concept of you need to be able to have the structure, the governance in your company that enables you to comply with with the requirements by law. And this really changes. So under, for example, the FTC enforcement action, the $5 billion enforcement action against Meta, right, from a few years ago when it was Facebook, right? There were a lot of specific requirements with respect to governance. You're going to have an oversight thing, and you're going to have a third party thing, and because it's a really big company with super complicated data. If you are a 5 people company, do you need a super complicated structure? No. If you are a 50 people, if you're a 5,000 people, right? So basically, and this, by the way, echoes the same issue in the UK reform in connection with DPO. They're like, okay, we get it. We get that this is a requirement, but it doesn't have to be like this very specific thing. But and the pros and cons are this. The pros are this very complicated DPO requirement is not super value add for all companies. It's a
mhm.
value add for certain companies, but it's not a value add for all companies. On the flip side, if you don't have very specific requirements, you risk the chance of companies just not knowing what to do.
No.
And that is sort of a growing pain. But I think the real answer to your question is that if you don't call it a DPO or whatever, you need to make sure that you have in place the structure that allows this not to be done correctly and not to fall between the cracks. And does that mean you need to
Mhm.
have 5 DPOs? You need to have a CPO with a huge department. You need to have one person. You need to have an outside person. You need to have half a person. It depends on your size and your data and your needs, but you need to make sure that there is a process where every time something starts, you have a process that has a person that understands data
Mhm.
privacy that is involved from the get-go in order to make sure that you're compliant.
Yeah. Of course, there are a lot of misunderstanding. People think that data privacy is just a legal issue, and it's not. There is, of course, it starts with the law, but most of the solutions of how you are going to process personal data, it's not legal work. I mean, sometimes you got to change the process, the way you do things. Sometimes you got to implement a data privacy management software that's going to help you to comply with some other obligations. Sometimes just getting people trained and about some specific things, and sometimes it's paperwork. I mean, sometimes you gotta draft a disclaimer or something like that. So it's a mix of things, but it doesn't need to be a DPO, or you don't have to hold that title to deal with these whole things. But on the other hand, you don't necessarily needs to be a privacy lawyer to also deal with all the aspects of data privacy. People even misunderstanding the definition of data protection and data privacy, which they are complementary, but they are not the same thing. Data protection is one thing. You protect the data, but sometimes you don't process the data compliant with the legislation, and vice versa. So I feel that a lot of awareness and education needs to be done and to happen in order to make everybody understand what a data privacy is. At least that's the way I see, and that's the same thing that has happened in many other parts of the world. I mean, it starts with people talking more and more about data privacy, and at certain point that will make part of their routine. Hopefully that will make part of the routine. I don't want to hold you too long, but just to finish here, there is the consumer rights. Can you just go over the rights? Because I think that we can't finish our podcast without talking about it.
Without the rights, yeah. So this
Yeah.
generally tracks CCPA, obviously generally tracks GDPR as well. First of all, one thing that that's really important is the emphasis on transparency. And this we see in the CCPA regs as well. There is a huge emphasis on the requirement to provide the information to people in a way that people understand what is going on. And the fact that this is spelling out this sort of weird, not weird, but sort of unclear rule from the FTC with respect to when you need consent when you change things. So you need consent when you make a material change to your privacy policy or practices. You need to notify people. You need to give them opportunity to withdraw their consent. So this is really important because this transparency issue, we see it in Europe. We see cases where companies have been dinged for, insufficient, unclear, vague privacy notices. I mean, you read a privacy note, it's like, oh, you're giving us consent for legitimate purposes. What is a legitimate purpose? What am I consenting to? I don't understand what you're talking about, right? So this is, in the European context, right? Like we process the information for any of the following legal basis, like what information and what legal basis? And am I like, is this like a mix and match game? Like, no. So this is one thing where we are kind of, making it the same standard, I think, as in Europe. You also have other rights are generally tracking CCPA. So the right of access, the right of rectification, correction of the information, accurate information, the right to deletion. Right now, the timing is 45 days, which is similar. 30 days, sorry, like GDPR, and not 45 days like CCPA. We'll see if that sticks. So those are kind of the same. And then there are rights for consent and opt-out. So you need consent for processing sensitive information. This is the same as the Virginia law. And consent needs to be easy to revoke. And you also have objection in certain situations for sharing information with third parties. And then they also are saying, so there's a big discussion and big debate in the CPRA context with respect to the global opt-out mechanism and kind of browser-based opt-outs and things like that. Was also a big discussion in Europe in the context of the e-privacy regulation, again, with how to do this in the browser or not in the browser, and is the technology really able to communicate your particular choices, or is it sort of too general? So that also punts the federal law also punts this to the FTC. So basically you have the similar rights to the rights under GDPR, which is transparency, access, rectification, deletion, objection to certain uses, consent in certain situations. And so I think, and of course, and non-discrimination. So I think generally speaking, this menu of rights is similar to the rights that we see under CPRA and under GDPR.
Perfect. Well, just one last question. I want your opinion about the preemption, just because I feel that this is a hot topic and something that we've seen debates in the Congress. So I just wanted to understand what are your thoughts about the preemption?
I think they reached some sort of compromise. I don't know, and I've been reading some of the Hill gossip, right? I don't know if it's a sufficient compromise, if it's still going to change. There have been people saying, okay, this is going to change. This is not where, the preemption is going to end. But basically, there is a compromise here because they do, same as, by the way, with the private right of action, which we didn't talk about, which was the other thing, which they gave sort of a, 4-year like break, kind of getting used to it period where you don't have the private right of action, right? So until like and the rush of excitement, okay, we're not going to be able to do it. Then when it's more established, okay, then we can do it. So this is also a compromise, right? The compromise is there is preemption, but it's not for everything. So one concern, the pro preemption were like, well, we can't have 50 different state laws. This is a nightmare, right? And so it does preempt the state privacy laws, but it doesn't preempt things like federal laws, like it carves out Gramm-Leach-Bliley, Fair Credit Reporting Act, HIPAA, FERPA. So you have a carve out for that, but it's only with respect to the data subject to those laws. So if you are a covered entity under HIPAA, which processes PHI, you have a carve out with respect to the PHI, but not the non-PHI. So you don't get a free pass for like your cookie information and things like that. You also have a carve out for baby FTC acts, obviously, because that's sort of the FTC enforcement, which is deceptive and misleading, and we've seen a nice enforcement uptick in those laws. Civil rights acts. There is a special protection version, the CCPA, private right of action for data breach. So generally, private right of action has a 4-year pause, but not the one under CCPA for data breach. Carve out for BIPA, the Illinois biometrics, carve out for GINA, the genetic law, protection of employee information. So CPRA, now coming in January, is upgrading protections to employees. Employees get consumer rights, and that is protected under CCPA. It basically gives the states, none of the other state laws are doing it, but theoretically additional state laws could do it, and COPA is not. And also it anticipates additional regulations under COPA. This has been something that has been anticipated for a long time, is the new regs under COPA. The FTC has talked about it. So we are going to, so COPA stays, but COPA will be beefed up, and then COPA can handle the under 13. We'll see how it goes with the under 17s, because now we have the 13 to 17 group that is different, but it might be, because there are discussions about this, of extending COPA age-wise. So that might fill the gap there.
Okay. Odia, thank you so much for sharing with us. Like, for me, it was a lecture. I mean, I now I quite understand, the differences between my background as an European and Brazilian lawyer. Get Global International slogan is data privacy nowadays is global, because it is. In multinational companies, they need to deal with different standards. And now we are trying to understand what's going on in the US and what is this American way of regulating data privacy. I quite like it. I think that there are things that we'll have to wait a little bit more. But definitely your opinion on each one of those topics clarify to us the meaning and the difference between things. So once again, thank you so much for being here with us.
Thank you very much. My pleasure.
Okay, guys, thank you. So I hope you have enjoyed this episode, and I'll see you next week. Bye-bye.